Welcome to The Explainer, where today we are unraveling a high-stakes legal mystery involving one of the absolute richest men on the planet and the U.S. justice system. We're looking at a story that has completely captivated the global financial world. I mean, it's got it all: massive billion-dollar investments, shifting geopolitical winds, and a bombshell legal reversal that frankly left experts completely stunned. So we're going to break down exactly what happened step by step, using the actual documents and reports that have chronicled this truly extraordinary case.
Okay, let's just dive right into this massive figure on the screen: $250 million. That was the estimated amount in alleged bribes sitting right at the center of a severe U.S. federal indictment against Indian billionaire Gautam Adani and his associates. The authorities basically claimed this money was used to secure incredibly lucrative solar energy contracts. Now, to put that into perspective, in the realm of international business law, an allegation of $250 million in bribes, that is an absolute earthquake. It's the kind of figure that normally kicks off years, if not decades, of grueling, high-profile litigation. But as you'll see, this case took a completely unexpected turn.
Because in a stunning reversal, the U.S. Department of Justice officially requested the court to just throw out all criminal charges against Gautam Adani. Just like that, an earth-shattering case that had sent shockwaves through global markets and literally wiped billions off corporate valuations overnight effectively vanished. The prosecutors themselves just walked away from it. To really understand how shocking this dismissal is and why it has sparked such intense debate all over the world, we need to rewind and look at how this whole thing actually began.
So let's jump into our first section, the original charges, rewinding to November 2024.
Picture this. It's late 2024, and a U.S. federal grand jury in Brooklyn unseals a massive, highly severe 5-count indictment. The Department of Justice and the Securities and Exchange Commission, the SEC, leveled heavy allegations against Gautam Adani, his nephew Sagar Adani, and several other executives. And they weren't messing around. They were looking at conspiracy to violate the Foreign Corrupt Practices Act, which is essentially a very strict U.S. law against bribing foreign officials, plus multiple counts of securities and wire fraud, and even conspiracy to obstruct justice. They were pointing to what they alleged was deep systemic corruption.
According to the prosecutors, this was a highly specific, 3-step playbook. Step 1, agreeing to pay over $250 million in bribes to local Indian officials, specifically calling out places like Andhra Pradesh. Step 2, using those exact bribes to win massive, highly profitable solar energy contracts. And Step 3, which is really what brought the U.S. into the picture in the first place, defrauding U.S. investors. The core allegation was that the Adani Group raised billions of dollars in American capital markets by explicitly lying to investors about their anti-corruption compliance.
All right, that brings us to our next section, the $10 billion pivot, where we see a massive change in strategy and administration.
So as we moved from 2024 into 2025, the political environment in the U.S. shifted significantly with the transition from the Biden administration to the Trump administration. And right alongside that shift, Adani's legal strategy experienced a massive pivot of its own. Adani hired a new legal team led by Robert J. Giaffer Jr., who, notably, also serves as a personal lawyer to Donald Trump. But according to reports, this new team didn't just file your standard, run-of-the-mill legal motions. No, they reportedly went straight to the DOJ with a comprehensive 100-slide presentation aiming to completely change the narrative and convince the government to drop the charges altogether.
Now, what's incredibly interesting here is the stark contrast between the two narratives that emerged. On one side, we have the official explanation from the DOJ for dropping the case. In May 2026, they went on record stating the case was primarily foreign, legally flawed, hard to prove, and effectively just a name-and-shame indictment with no real prospect of going to trial. They also said it was inconsistent with current agency priorities. But on the other side, flip over to what the media was buzzing about. Around the time of the U.S. election, Adani publicly pledged to invest a staggering $10 billion in the U.S. and create 15,000 American jobs. Outlets like the New York Times immediately began questioning if this prominent financial pledge was the actual catalyst for the dropped charges. Because of all this media scrutiny, the federal judge overseeing the case actually demanded answers. So, for the record, Gautam Adani formally submitted a sworn declaration, meaning he stated this under penalty of perjury, that he was not aware of any agreement where his investment was exchanged for the dismissal of the indictment. His legal team strictly maintained that the investment was never offered as a quid pro quo.
a favor for a favor. However, his lawyers did admit in court filings that the $10 billion pledge was in fact discussed with the Justice Department as a possible part of resolving the broader matters.
This incredibly complex situation leads us directly to our next section, the judge's reluctant ruling. Let's unpack how this dismissal actually played out in court.
Fast forward to August 2026, when U.S. District Judge Nicholas Graufus had to make the final call on officially tossing the case out. Now, legal experts will tell you that judges actually have very little discretion to force prosecutors to pursue a case that they want to drop. So the judge ultimately did approve the dismissal. But let me tell you, he did not hold back his sharp criticism. He literally wrote, "The irregularities in the decision to dismiss the indictment are concerning." He specifically called out a senior DOJ official named Trent McCotter, who allegedly bypassed the career prosecutors and FBI investigators who were directly handling the case, substituting his own judgment to push the dismissal through.
Ultimately, the court granted the DOJ's motion to dismiss the case with prejudice. And you absolutely need to know what that phrase means, because it is a massive permanent legal victory for the defendants. Dismissing a case with prejudice means the criminal case is permanently closed. The government cannot simply wait a few years, gather some more evidence, and try to refile these exact same criminal charges against Gautam Adani or his associates. Nope, that door is legally and permanently shut.
But, and this is a big but, while the criminal charges vanished into thin air, the Adani Group didn't walk away completely untouched financially. As you can see here, they agreed to pay hundreds of millions in separate parallel civil settlements. Gautam Adani agreed to pay $6 million and Saga Adani $12 million to the SEC regarding investor disclosures. Furthermore, Adani Enterprises agreed to pay a whopping $275 million to the DOJ to settle potential civil liability over apparent violations of U.S. sanctions on Iran. Now, what's the most crucial detail here? They paid these massive sums without officially admitting or denying any wrongdoing. It was basically a strategy to clear the board entirely and move forward.
So that wraps up the U.S. side of things, but it leads us perfectly into our final section, unanswered questions in India, focusing on the global repercussions and equal justice.
Because while the U.S. criminal case is firmly closed, the ripple effects are sparking some really intense debates regarding sovereignty back in India. Court documents reveal this incredible behind-the-scenes battle that was happening. Throughout 2025, the SEC was desperately trying to formally serve legal summons to the Adanis in India. But look at this timeline. In May and then again in December, India's Ministry of Law and Justice outright refused to serve them. They cited all sorts of technical objections, missing signatures, official seals, which effectively blocked the U.S. regulators. It got so ridiculous that by 2026, the SEC actually had to go to a New York federal court and ask for permission to bypass standard international protocols and just, well, email the legal notices.
This entire dynamic has led to intense media scrutiny within India. Editorial commentators are raising some really fascinating questions about whether high-profile billionaires are treated with a completely different set of rules. For example, people are publicly asking if a massive financial case can be settled by dropping criminal charges alongside a $10 billion investment pledge in the U.S., shouldn't the Indian government apply that exact same logic at home? They're pointing to other accused economic offenders who fled India, figures like Vijay Mallya or Nirav Modi. The media is asking, neutrally but very pointedly, if international law treats the ultra-wealthy who can negotiate billion-dollar pledges differently than standard economic offenders.
Which leaves us with this incredibly provocative final thought to reflect upon. We have just watched a $250 million bribery allegation disappear. We've seen $10 billion investment pledges, sudden shifts in government policy, and hundreds of millions paid in civil penalties without a single admission of guilt. It really forces us to ask a profound question. When billions of dollars are on the table, does true equal justice even exist in international law? Or are the scales inevitably tipped when geopolitics, immense wealth, and national interests intersect? It's a fascinating question, and one that is going to shadow this case for years to come. Thanks for joining me on this explainer, and keep questioning the world around you.